Well, first they made the representation that the House is claiming there is no such thing as executive privilege. That's nonsense. No one here has ever suggested there's no such thing as executive privilege. But the interesting thing here is they've never claimed executive privilege. Not once during the House investigation did they ever say that a single document was privileged or a single witness had something privileged to say. And why didn't they invoke privilege? Why only now? And even now they haven't quite invoked it. Why only now? Why not in the House? Because in order to claim privilege, as they know because they're good lawyers, you have to specify which document, which line, which conversation, and they didn't want to do that because to do that, the president would have to reveal the evidence of his guilt. That's why they made no invocation of privilege. Now, they make the further argument that the House should only be able to impeach after they exhaust all legal remedies, as if the Constitution says the House shall have the sole power of impeachment, asterisk, but only after it goes to court, in the district court, then the Court of Appeals, and then en banc, and then the Supreme Court, and it's remanded, and they go back up the chain, and it takes years. Why didn't the founders require the exhaustion of legal remedies? Because they didn't want to put the impeachment process in the courts. And you know what's interesting is that while these lawyers for the president are here before you today saying the House should have gone to court, they are in court saying the House may not go to court to enforce its subpoenas. I kid you not. Other lawyers, maybe not the ones at this table, but other lawyers for the president are in court saying the exact opposite of what they're telling you today. They're saying you cannot enforce congressional subpoenas. That's non-judiciable. You can't do it. Now, they also made the argument that you'll hear more later on from apparently Professor Dershowitz that, well, abuse of power is not an impeachable offense. It's interesting that they had to go outside the realm of constitutional lawyers and scholars to a criminal defense lawyer to make that argument because no reputable constitutional law expert would do that. Now, they say, oh, the president is very transparent. He may have refused every subpoena, every document request, but he released two documents. The document on the July 25th call and the document on the April 21st call. Well, let's face it. He was forced to release the record of the July 25th call when he got caught. When a whistleblower filed a complaint, when we opened an investigation, he was forced because he got caught. You don't get credit for transparency when you get caught. And what's more, what's revealed in that, of course, is damning. Now, Mr. Cipollone made the representation that Republicans were not even allowed in the depositions conducted in the House. Now, I'm not going to suggest to you that Mr. Cipollone would deliberately make a false statement. I will leave it to Mr. Cipollone to make those allegations against others. But I will tell you this, he's mistaken. He's mistaken. Every Republican on the three investigative committees was allowed to participate in the depositions, and more than that, they got the same time we did. They make the argument the president was not allowed in the Judiciary Committee, chaired by my colleague, Chairman Nadler, to be present, to present evidence, to have his counsel present. That is also just plain wrong. Just plain wrong. When you hear them attack the House managers, what you're really hearing is, we don't want to talk about the president's guilt. We don't want to talk about the McConnell resolution and how patently unfair it is. We don't want to talk about how to pardon the expression, ass backwards it is to have a trial and then ask for witnesses. And so we'll attack the House managers because maybe we can distract you for a moment from what's before you. Maybe if we attack the House managers, you'll be thinking about them instead of thinking about the guilt of the president. So you'll hear more of that, and every time you do, every time you hear them attacking the House managers, I want you to ask yourselves, away from what issue are they trying to distract me? What was the issue that came up just before this? What are they trying to deflect my attention from? Why don't they have a better argument to make on the merits? Finally, Mr. Sekulow asks, why are we here? Why are we here? Well, I'll tell you why we're here. Because the president used the power of his office to coerce an ally at war with an adversary at war with Russia, use the power of his office to withhold hundreds of millions of dollars of military aid that you appropriated and we appropriated to defend an ally and defend ourselves, because it's our national security as well. And why? To fight corruption? That's nonsense, and you know it. He withheld that money, and he withheld even meeting with him in the Oval Office, the president of Ukraine, because he wanted to coerce Ukraine into these sham investigations of his opponent that he was terrified would beat him in the next election. That's what this is about. You want to say that's okay? Their brief says that's okay. The president has a right to do it. On Article 2, we heard the president, he can do whatever he wants. You want to say that's okay? Then you got to say that every future president can come into office and they can do the same thing. Are we prepared to say that? Well, that's why we're here.
It seems that one small detail the Trump legal team overlooked is that they're not parroting White House talking points on Fox News anymore, and that there are actually people on the other side willing to call them out for lying. So when Pat Cipollone and Jay Sekulow opted to use their time to spout easily debunkable lies, they set themselves up to be embarrassed on the Senate floor. Now, Schiff dives right in, starting off by explaining why the White House wouldn't actually invoke executive privilege on Trump's conversations and documents between he and the administration officials implicated in his extortion scheme. That never stopped those officials, however, from going on every cable news show there is and wailing about how forcing administration officials to appear is a violation of that privilege. In other words, they wanted the benefits of invoking privilege without any of the legal consequences. And beyond that, the administration knew that invoking executive privilege would have been a fool's errand. According to Supreme Court precedent, when Richard Nixon tried to claim executive privilege over the recordings that would eventually show the smoking gun that he coordinated the cover-up of Watergate, the Supreme Court not only ruled against Nixon's executive privilege claim, they ruled against it unanimously. The court said expressly that the historic commitment to rule of law outweighs a president's generalized need for privacy, and that because Congress is tasked with investigating wrongdoing by the president and ultimately deciding impeachment, the interest of those investigators uncovering the truth would outweigh a president's interest in keeping communications private. In other words, if the legislative branch's request for information or witness testimonies is pitted against executive privilege, it's Congress that will prevail. Also, it should be noted that according to the 1974 ruling, presidential privilege is, quote, limited to communications in performance of a president's responsibilities of his office made while shaping policies and decisions. But Trump is accused of using his presidential powers to shape policies and decisions that advance his own personal interests. So even if he could claim privilege, it still wouldn't cover the information that he's trying to shield. Sekulow went on to say that the House should have waited for the courts to render judgments on their challenges to subpoenas, but the Trump administration has argued in federal court for months now that the courts shouldn't play a role in resolving disputes between the White House and Congress. I mean, listen to the Trump administration's own argument. They say, quote, the now very real possibility of this court appearing to weigh in on an article of impeachment at a time when political tensions are at their highest levels, before, during, or after a Senate trial regarding the removal of a president, puts in stark relief why this sort of interbranch dispute is not one that has traditionally thought to be capable of resolution through the judicial process. In other words, the White House is claiming all at once that if Democrats wanted witnesses, they should have called them, but that they'll fight the ability of those witnesses to appear in the judicial system, but also that Democrats have no right to bring it to the judicial system because the courts have no place in the impeachment process. It's almost like this is nothing more than a barrage of bad faith arguments from an administration only interested in helping cover up the president's crimes. Schiff goes on to slam the defense brought up by Alan Dershowitz that suddenly abuse of power is not even an impeachable offense.
Is it your position that President Trump should not be impeached even if all the evidence and arguments laid out by the House are accepted as fact?
That's right. When you have somebody who, for example, is indicted for a crime, let's assume you have a lot of evidence, but the grand jury simply indicts for something that's not a crime, and that's what happened here. You have a lot of evidence, disputed evidence, could go both ways, but the vote was to impeach on abuse of power, which is not within the constitutional criteria for impeachment, and obstruction of Congress. Those are both the kinds of things that led Hamilton and Madison, talk about nightmare, to regard that as the greatest nightmare. Number one, giving Congress too much power to allow the president to serve at the will of Congress. And number two, as Hamilton put it, the greatest danger is turning impeachment into a question of who has the most votes in which house, and rather than having a consensus and a broad view of impeachable conduct.
Now, Dershowitz claims that Trump can't be impeached for abuse of power because it's not a statutory crime, meaning that it's not a specific violation of the law that anyone could otherwise be convicted of in a regular court of law. He even goes on to invoke Alexander Hamilton in his defense, which makes the fact that Hamilton himself actually wrote the words that completely disprove Dershowitz's argument all the more humiliating. Hamilton wrote that impeachable offenses involve a, quote, abuse or violation of some public trust, and, quote, relate chiefly to injuries done immediately to the society itself. As a result, the impeachable standard of high crimes and misdemeanors did not by any stretch of the imagination require those acts to be violations of federal statutes, but instead encompass acts committed by public officials that inflict severe harm on the constitutional order. And just throwing this out there, but I'd assume that running an international extortion scheme wherein you leverage nearly $500 million as a bribe to a foreign country to hand you dirt on a political opponent probably falls under Hamilton's definition of an abuse of public trust and harming the public order. Cipollone then claimed that Republicans weren't allowed into the SCIF, the secure room, during witness depositions in the early stages of the impeachment inquiry.
In every other impeachment proceeding, the president has been given a minimal due process. Nothing here. Not even Mr. Schiff's Republican colleagues were allowed into the SCIF.
And this harkens back to Matt Gaetz' stunt, wherein he tried to, quote, storm the SCIF to expose these super top secret hearings in the basement of the Capitol. Only they weren't so much secret as they were open to literally any Republican who sat on the appropriate committees. And those Republicans got to speak just as much as the Democrats. In other words, it was a stunt that backfired immediately. And yet for some reason, Cipollone decided that it would be smart to dredge up one of the single most debunkable lies in his desperation to frame the inquiry as unfair. And finally, Cipollone says that Trump wasn't allowed to be represented or afforded due process during the impeachment inquiry.
The proceedings took place in a basement of the House of Representatives. The president was forbidden from attending. The president was not allowed to have a lawyer present.
Which, yet again, is a lie. Once the time came for Trump's lawyers to be interviewed in that inquiry, which again was not a trial but was intended for fact-finding, they declined. In other words, the White House refused to show up and then complained that they weren't able to show up. And look, I can go on from now until forever, but here's what this all shows. It shows that the Trump administration doesn't have anything even resembling an effective defense. If the best they could do on day one, hour one of this impeachment trial, with the eyes of the entire nation upon them, is to not only lie, but lie so lazily, lie so egregiously that Adam Schiff would be able to systematically debunk every single talking point and destroy their credibility in an instant, then that really does not bode well for this White House as we continue on in this trial. But aside from that, it also shows something more insidious, and that is that they don't actually care about arguing the merits of this case. They're performing only for Trump and his low information base that'll never bother to second guess anything that the president says. Their approach is clear. They'll lie from the beginning right down to the bitter end, because while they might know that they're being dishonest, they're banking on the fact that enough of Trump's voters don't. Their strategy is nothing more than to continue with their exploitative tactics that landed Trump here from the very beginning.